Check. Check. Hello. Akito Sab? Akito Sab?
Yes, Kusa, I can hear you.
Yeah,
Can you
yeah.
hear me?
Yeah.
Am I breaking up today?
I just wanted to check out.
Am I breaking up today or is it fine?
It's quite fine. It's quite fine.
Okay, okay. Good.
May I please, Your Lordships? Lordships, I beg to mention item number 39, Lordship. Item 39.
Yes.
Lordship, here I'm for respondent number 2, 3, 4, and 5, Lordship. Lordship, just recently only we have received the instruction, Lordship. So if Lordship may please to grant another 3 weeks time to file our FD.
Your Lordship,
What about CGC?
Your Lordships, wait. Aye, my lords?
Yeah.
Am I audible, my lords?
Yes.
Yes, item 39. Now, Your Lordship, it is a time. It is
39.
yes, my lords.
Not
So it is
audible.
Am I audible, my lords?
Now.
Yes. Yes, Your Lordships. So it is at times like this that the importance of the alternative route to Kohima comes into the picture. Now, my lords, yesterday, last evening, from last night, National Highway 29 has been completely cut off.
Yes.
The portion between the Chupitama gate up to that Dhansi Bridge, up to the Paglabhar area, not only landslides and rock falls, but the road itself has collapsed. And then further up ahead towards Perima, the entire hillside is falling apart, Your Lordships. Now, it looks like this stretch of road is going to take some time to get repaired. This National Highway 329A, this is the alternative route. And there is already a direction by this Honorable Court that this road should be constructed within a period of 3 years. And the order was passed, Your Lordships, on 17/11/2021.
Yes.
So now what remains is for the respondents to answer when they are going to construct this road. Nothing more, Your Lordships. And especially given the circumstances that we are in now, it is more urgent and it is required of the respondents to move and take action forthwith.
Which is this route?
This is the 329A. This is from Sanktam Tila to Kyoto to Shokhavi to Pimla Junction to Mahinamsi and Jaluki, and then it comes out in Janapani. This is the alternative route, Your
You are
Lordship.
not audible, Mr. Jimomi.
Your Lordship, this route, am I audible now, Your Lordship?
Yes.
So this route is from Sanktam Tila here in Dimapur, in the Assam border, Difu border, from Sanktam Tila to Kyoto village, to Shokhavi village, to Pimla Junction, and from Pimla Junction to Mahinamsi. Then this connects with 129A, which then comes out in Jharnapani. So this is the alternative route.
You are not audible.
Am I audible now, Your Lordships? So this is the alternative route, Your Lordship, which we take whenever National Highway 29A is blocked.
Yes, Mr. B. Jimomi,
Lordship.
I think it is high time that the government gives us an alternative route.
Lordship.
I think the government cannot play with the lives of the people. We are experiencing that the national highway is completely cut off. And this has been regularly happening every year.
Lordship.
And we also expect the government actually to have at least some alternative option
Lordship.
where the commuters will not be inconvenienced. But we find that the government is lazily taking all this, taking the people for a ride, taking the hardship of the people as if nothing has happened, as if everything is going on smoothly. I think this should not be the attitude of the government. The government is for the welfare of the people.
Lordship.
And this is not a new thing. The National Highway 39, the soil is very unstable. Every year, it is either one place or the other where we are having this. And this time, I don't know, I have not seen it. But as per the photographs displayed, I think the situation is a little serious,
Lordship.
where the whole road is.
Collapsed, my lord.
uh,
The road itself has collapsed.
So I think your concern for the people should not be only in the form of an affidavit. I think it should be in the form of an action.
Lordship.
So, my lords, so this alternative route, which we usually take when National Highway 29A is blocked, that needs immediate attention. And that is National Highway 329A, my lord. That is the alternative route. And National Highway 329A, that is the subject matter of this PIL, my lords.
Yes, Mr. Vijaymomi, tell us what is the best option. Tell us.
Lordship.
How do you make this road available to the public
Lordship, in
in
this
this
case,
kind of emergency?
Lordship, in this,
Or else we summon the commissioner secretary.
Lordship, in this instant PIL, I'm led by my senior additional AG LT Santam, Lordship. But
So
he has
what?
some personal difficulty today,
That-
Lordship.
That's no excuse. Just because LT Sankam is not there, we cannot put the people into inconvenience. Something has to be done.
Lordship, earlier this road was looked after by the NHTCL, Lordship.
It is
Now
not by
proposal,
under the state.
now for that matter, Lordship, the proposal has been sent to the ministry to hand over to the state government.
No, but at least it is the
Until such
responsibility
time,
of the state to at least make it pliable.
Lordship.
At least the comfort of the people should be seen.
So as of till that, Lordship, the proposal has been sent to the
You have an
government
elected
in-
government. If the government is not looking after the welfare of the people, who will look after the welfare of the people?
Lordship.
I think it's high time the government does something. And there is a judicial order.
Lordship.
Tell us what is to be done. If not, we summon the commissioner secretary. We take an undertaking from him.
Lordship, in that way of the matter, Lordship, if this matter can come up tomorrow or day after tomorrow, Lordship, since I'm led by my senior LT Santam.
Yes, tell him to come with something concrete,
Lordship.
not affidavit, no affidavit,
Lordship.
not seeking time for affidavit.
Lordship.
Tell him to get some concrete instruction
Lordship.
as to when this road will become pliable for the public,
Lordship.
as to when this road will serve as an alternative road for
Lordship.
the public. At least come with some instructions, not always affidavit.
Lordship.
We are not concerned with the affidavit. We are concerned with the road.
Lordship.
We fix it next Wednesday.
Lordship.
Tell him to come with instructions.
Lordship.
If not, we summon the secretary, so
Lordship.
commissioner or secretary, whoever,
Lordship.
and we get an undertaking from him.
Lordship.
Yes, Mr. Jimomi, next
Yes,
Wednesday,
my lord. Yes, my lord. Next Wednesday.
on the prayer of Mr. V. Jimomi, the learned government advocate, listed on, when is next?
11.
Listed on 11/9/2024. Mr. V. Jimomi,
Lordship.
kindly convey the concern of this court to the department or to the government, whoever is responsible,
Lordship,
and tell him to tell your additional AG to come with instructions.
Lordship,
If not, we are going to summon the commissioner secretary.
Lordship,
We want undertaking from the government.
Lordship.
Okay.
Much obliged, my lords.
Lordship, I beg to mention item number 41, Lordship.
Yes,
Lordship, here I'm for respondent number 1, 2, and 3, Lordship.
R1,
1, 2, and 3. Lordship.
yes.
Okay, my lord, we are yet to receive instruction, Lordship. So if Lordship may please to grant another 3 weeks time.
This is detention.
Lordship, in fact, just recently only we received the extra copy from the petitioner council, Lordship. And accordingly, we have intimate to the respondent.
What
respondent
about CTC?
My lord, I had a similar prayer.
We give you last 2 weeks' time to come with the instruction. If not, we dispose on the basis of materials available on record. Okay,
My lord. I'm for respondent number 4, my
Mr.
lord.
V. Jimomi, learned government advocate for the respondent number 1, 2, and 3. And Mr. Zatin Mulye, learned CGC for the respondent number 4, are allowed 2 weeks' time to file their affidavit in opposition. It is made clear that no further adjournment shall be granted. And on the next date, if no affidavit is filed, the case shall be disposed on the basis of materials available on the court. Okay.
May I please your lordships?
Yes.
Lordships, I beg to mention hearing item 43, 44, and 45, lordship. Your lordships may be gracious enough to kindly refix this matter on 25, lordship. I've taken the consent of the.
What is so auspicious on 25th?
Lordships, my senior has a personal difficulty, lordship.
On the prayer of Mr.
V. Koza, lordship.
V. Koza,
Lordship.
learned counsel for the petitioner, listed on 25/9/2024.
Much obliged.
Yes.
May I please, Lordship?
Yes,
Lordship,
Mr.
I'd like to
Lima.
mention for item number 40. Lordship, in this case, I'm led by my senior Tali Ao.
Okay.
Lordship, because of the road condition, it will not turn up. So after 2 weeks, Lordship.
Item 40,
Yes, Lordship.
Mr. Limawabang, learned counsel submits that. Mr. Tali Ao, the learned counsel for the appellant, is unable to give his presence in the court today due to the bad road condition, and therefore seeks adjournment of the case for 2 weeks.
After 2 weeks.
2 weeks. Prayer is allowed, listed after 2 weeks. So
May I please, Your Lordship?
yes, yes.
On behalf of RA Roma, the counsel for respondent number 1 in item 49, hearing item 49.
Yes.
With the consent of the appellant counsel, we have
Respondent
a
number
joint
1.
prayer. Yes,
Respondent
my
1.
lord. Yes, my lord.
Yes, Mr. Mazui, you are in this case.
Yes, Lordship, apparently in the writ petition, the officer of the Accountant General had name was deleted. However, when the appeal was referred again, we have been made a party.
The cause list shows you are for R2.
Yes, Accountant General Office.
Okay.
And this is a matter pertaining to SBI. Nothing to do with us. The petitioner was an employee of the SBI. So we have apprised the court that we are not necessarily part of this case. And our name was deleted in the writ petition. But when the SBI, they preferred an appeal, we have been made a party again.
Okay. Mr. Pakin Richabo. Learned counsel makes a mention on behalf of Mr. R.A. Romay, the learned counsel for the respondent number 1, and seeks adjournment of the case for
After 3 weeks.
for 3 weeks. Okay. Prayer is allowed, listed accordingly. Stop. on the next date fixed, the learned counsel for the learned counsel for the petitioner shall address this court as to why the accountant general, that is the respondent number 2, has been made a party in the case.
Your worship.
Okay, okay.
Obliged, Your worship.
Honorable.
May I please, your lordships?
Yes.
I'd like to mention item number 48 hearing.
Huh?
Item number 48,
Keep only.
let the matter come up to 3 weeks.
After 3 weeks. Okay.
Yes, your worship.
On your good name?
Nang saya.
Okay, on the prayer of Mr. Nang Sangayer, learned counsel for the appellant, listed after 3 weeks. Okay.
May I please, your lordships?
Yes, please.
I beg to mention item number 2 to 35 on behalf of my senior Nityo Koza, counsel for the petitioner. She is indisposed and I've been instructed to seek 2 more weeks to file additional affidavit.
Okay, let it come as per the list. As per the list. At last, let us see what was the last order passed. Okay, as per the list. Okay.
Your Lordship,
Yes, ma'am.
I beg to mention item number 38 on behalf of my senior Nito Kosa, counsel for petitioner, will be filing an
38,
additional.
okay, let it come as per the list. 38. As per the list. As per the list.
May I please, your lordships?
Yes.
Lordships, I beg to mention hearing item number 47, lordship. 47. Lordship, if this matter can come up after 3 weeks, lordship.
You're
I'm appearing for the appellant, lordship. My name is Inda Bakalat Mahav, it's not
okay,
shown in the
your good
process.
name?
Mika H. lordship.
Mika H.
Aye.
Okay, Mika H. MS Mika H. Aye, the learned counsel for the appellant. 6 adjournment of the case for 3 weeks. Okay, prayer is allowed, listed accordingly. The name of MS Mika AIME shall be reflected in the daily course list as the learned counsel for the appellant. Okay.
Much obliged.
For motion from the supplementary course list, item number 50.
May I please, your lordship?
Yes.
Your lordship. Yes. Your lordships,
Yes.
I regret to mention that in the main petition, I have inadvertently made some irregularities.
Okay.
The other petitions are okay, but the course title, I have made a mistake in the dates. Your lordship may kindly allow me to rectify this and
Which,
matter may be listed for motion in the next DB, your lordship.
I think you will have to file a petition for amending the course title. Is it? Because we cannot rectify in the petition. Or else
Your
you.
lordship, your lordship, I was thinking to file a fresh, but then I need to bring that fresh vakalat nama, and since the accused person is at central jail and with the depletion of the road condition, it might take some time, your lordship.
No, but like to make changes in your course title,
Yes, your lordship.
you have to amend the course title. You have to file an application. We cannot just allow you to make some correction entry in this course title.
Your lordship, then I'd like to withdraw and file a fresh.
Yeah, I think that should be better for you. Your good name?
Kreke.
Cricket Tonyo.
Yes, your
Cricket
lordship.
Tonyo.
Yes, your lordship.
MS Cricket Tonyo. The learned counsel for the petitioner submits that she has instructions to withdraw the writ petition with liberty to file afresh. Writ petition is accordingly allowed to be withdrawn with liberty to file afresh. Okay.
Much obliged, your lordships.
For admission, item number 1.
What is the last order passed?
On the earlier date, Lordship, my affidavit was not on record, Lordship. I believe it is already on record. The status report of the work,
When is your affidavit dated?
28th of August. On the day the order was passed, Lordship.
28.
Yes,
Let
Lordship.
us see.
Respondent number 10. I filed on the morning of 28/8/2024.
28.
28th August, Lordship. In that affidavit, the status report is as on 13th of August 2024.
Physical progress,
74.23%, Lordship.
physical progress 74.23
23.
and
Financial
physical,
progress of 72.
no, physical progress 74.23.
Yes, Lordship.
Where is that financial progress? Which page?
Lordship,
Which page?
page number 3, Lordship.
Page.
Page?
Page 3. 3.
Page 3 at the bottom of the page, Your Lordships.
It is given in both, Lordship. Both the financial progress as well as the physical progress. As on 13 August 2024.
Is it the actual picture, Mr. Santi?
Yes, Lordship. Lordship.
This is the actual picture.
Yes, Lordship.
So if physical progress is 74,
Yes, Lordship.
that means at least there is some substantial progress.
Yes, Lordship. But
Yes, Mr. Ejmomi, what do you say?
So, Your Lordships, two things. The first point which I'd like to make is that the SLP which was filed by the contractor is listed for 3rd of December this year.
Okay.
The SLP on the ROW issue. And the second point, Your Lordship, is that the time for completion is 31st May. So we are beyond the deadline. So the question now which arises is, what do the official respondents as well as the contractor, what are they going to do about this? That's the point, Your Lordship. And the other point is, because of the heavy rains, now there is substantial damage in the road condition. So that issue also needs to be addressed.
regarding the maintenance, Lordship, I believe my brother Joshua, who is representing respondent number 9, Lordship, the contractor, my learned friend, I believe he'll be in a better position, Lordship.
Yes, Mr. Joshua, what is the maintenance?
Your Lordship, there has been a lot of unforeseen events, especially in terms of maintenance works, where more than what the contractor has anticipated has occurred, where we had to run into several crores of rupees by doing maintenance works, Your Lordship. My Lord, since as my learned senior colleague for the amicus curiae has already made a submission where before the Honorable Supreme Court, not only specifically on the issue of ROW, but other challenges also, Your Lordship. And the matter is fixed on 3rd of December, Your Lordship. And we are continuing with the work, but the situation, the condition has become extremely unfriendly for us to be able to continue with the work. So yesterday we have submitted a letter with an intent to terminate the ongoing contract work, as well as the NHIDCL, also the respondent NHIDCL, according to the affidavit which I received this morning, they have also issued NIT for maintenance and repair contractor, Your Lordship, to come in.
For maintenance repair?
Yes, my Lord.
NIT?
Yes, my Lord. NIT has already been floated.
What is actually the terms and conditions of the contract for maintenance? The original?
Your Lordship, if we go by the original contract, Your Lordship, all the maintenance work, Your Lordship, it is to be done by the contractor. But the situation has gone out of beyond the control of the contractor, my Lord. We see just this morning also we have the information of what is happening to the road conditions, Your Lordship.
This is this side, not this side.
Yes, Your Lordship, but the climatic condition is not different in this stretch also, Your Lordship, and over the years.
If
Yes,
there
Your
is
Lordship.
some adverse circumstances with the road, in view of the weather condition and all this, of course. But as of now, it is only this highway.
Yes, Your Lordship. But there was a landslide at Khuzama also, Your Lordship. So, my Lord, a clearance has been made where vehicles are plying, but we could not repair the road or construct the road to the extent of the original position that it was, Your Lordship. My Lord, yesterday we have already submitted.
Yes, what is the best option now?
My Lord, we have already submitted a letter with an intent to withdraw from this
To
work, Your
terminate.
Lordship. Yes, for termination.
Yes, who is the NHIDCL?
Lordship, I'm representing in HDC.
Yes, what happens?
Lordship, we have received last night a notice for intention of terminate, if I may be allowed to finish.
No, it's all right, you keep it. Just keep it.
Lordship.
Just,
On the last occasion, we have filed an affidavit on 21st of August, Lordship. Bringing, apprising this honorable court, Lordship, about what has happened, Lordship. We have also stated about the provisions under the contract agreement, Lordship, where there is provision under 10.4, 11.13, where we can invite new agencies by way of an IT, floating an IT, and to maintain and repair the road at the recent cost of the contractor, Lordship. Now, on the last occasion, as well as we have also filed an affidavit this morning, Lordship, seeking permission from this honorable court, if the road can be, if we may be allowed to go ahead with the NIT and appoint someone so that the road is maintained, Lordship.
yes, Mr. Joshua, it is at your cost. It is at your cost that the road is to be maintained.
Your
Whether
Lordship,
that will be a dispute.
that is a disputed question.
No, Lordship, it is
yes,
very
Your
much
Lordship.
part of the contract agreement, Lordship.
And if it is a part of the
And I have
agreement,
also produced a contract.
Your Lordship,
agreement.
here, unfortunately, as the progress of the work was affected by several circumstances, blame game does not help the road to improve, Your Lordship.
we are
So, Your
not- we are
Lordship,
not-
here, what the NHIDCL is saying is not necessarily what we accept, Your Lordship. And it is a disputed subject matter, my Lord. So, since there is an arbitration
So-
clause, my
so
Lord.
You have completely stopped your work, or
No, we are still continuing with a minimal workforce, Your Lordship, but we intend to withdraw from the work, Your Lordship, because it is not a work where every contractor needs some profit to execute the work.
Ah.
Here is a contract work where we are running into loss in terms of crores, my Lord.
you should have foreseen that.
My Lord,
You should
there are
have
some
foreseen that.
circumstances which,
You should have foreseen that you are a veteran contractor. You should have foreseen the climatic condition, the soil condition, everything before you could have undertaken such a huge contract.
my Lord,
See,
as far as several other states in India are concerned, my client, it's a reputed firm where we are known for
it's all
our
right.
quality works. But it was not a circumstance that was foreseen because this is the first time that we are, my Lord, we have been in the picture in executing this work.
So
And
now
yes, my
we
Lord.
will be on the affidavit filed by the
NHIDC.
NHIDCL.
I may be allowed to consult my client and then file a reply to this affidavit which the NHIDCL
And,
has filed this morning,
if
my
the
Lord.
contract so says that actually the maintenance should be at the cost of the contractor, then maybe you cannot escape that liability.
My Lord,
You just see, because we are not here to actually like impose any orders or directions
Lord,
on anybody.
my Lord.
We want to see that the road is completed for the benefit of
Lordship.
the people, that's all.
it's a huge liability they are trying to throw on my shoulders. So my Lord may kindly give me an opportunity also to,
It is the ink which speaks.
my Lord, your Lordship. And I will also reply accordingly, my Lord, as
Yes,
per
Mr.
the
Jimami.
contractual terms.
I think
Your Lordship, I think both the NHIDCL as well as the contractor, they are actually skirting on very big issue because the case in the Supreme Court is about the inability of the contractor to meet the deadline set by this honorable court because of the non-providing of the ROW. Now, at this juncture, if the contractor wants to recuse himself from the contract and the NHIDCL wants to give the maintenance work to some other person, it will only add to complications. I think the parties need to sit down and work something out, Your Lordships.
I think you are right. I think that is what I wanted to suggest because maybe I think some differences which can be chalked out with a proper meeting, with a proper sitting. Yes. And I think that will be more beneficial to the contractor
My Lord,
because as per the terms and conditions of the agreement, if any maintenance is to be undertaken, it has to be at your cost.
Lordship.
So why don't you sit down and then why don't you have a discussion? We will give you time for that.
My lord, your lordship.
We will give you time for that, but I think before we go into that petition, it'll be good if the NHIDCL and the contractor, if you can just have a very meaningful discussion
Lordships.
on this, so that your discussion will benefit the public and it will not prejudice any of you.
Lordships.
Have you filed the affidavit?
Yes, Lord.
Have you filed? Where is that
The
affidavit?
first, on 21st August, and the letters is this morning, Lordship. I filed one this morning, Lordship.
This morning's affidavit?
Yes, Lordship. I filed, Lordship, this morning, only this morning, Lordship. But we have also stated about all these grounds in the earlier affidavit, which I filed on 21st August, Lordship. We are compelled to issue this notice, Lordship, because there's hardly any progress for the last 2 months, Lordship.
Mr. Santi,
Yes, Lordship.
you are giving all this progress report on whose behalf?
On the behalf of the authority engineer.
Authority engineers.
Yes.
But Mr. Joshua, if this is the actual progress, then I think you have done at least some substantial work.
As far as if not spoiled by the weather gods, your lordship.
So just if we are to go by this, then it is only, I think, 26 remaining physical progress.
My lord.
That is within the ROW.
Existing ROW.
So why let all this controversy come in?
My lord, practically on the field and on technical considerations, your lordship, which the contractors and the NHIDCL will be the best to be able to assist the Honorable Court also, your lordship. The technical aspects have become extremely impossible for the contractor to continue with the execution of the work within the existing width of the road, my lord. So
I think that actually, see, the court may not have that expertise
my lord.
to actually give a suggestion on that. But I think both the NHIDCL and the contractor, with your expertise, with all your there's a technical backings and all this, I think you will be able to actually, I think, sit down and work out this issue.
My lord.
And when actually the liability is more adverse to you,
My lord.
as per the contract.
Your lordships.
So I think you should be the willing partner to invite the NHIDCL over a cup of tea.
Perhaps by the intervention of this Honorable Court, NHIDCL would also take it serious. If not, because of the clashes, time and again,
We are always there to help.
there's already an existence of cold shoulder.
So long as we do not go out of the way, we are always there to assist both the parties so that you can come to some agreement so that actually the work is
Lord.
completed.
Otherwise, Lordship, we have invited a contractor on several occasions, which he has missed.
Go.
So if
Sit.
the action is issued to the contractor specifically to adjust to it, Lordship. Otherwise, I have instruction that they have missed the meetings, Lordship.
So, Mr. Joshua, you just have some very fruitful and meaningful discussion with the NHIDC. At least we don't, at this stage, we don't want to see that the contract, this work goes wayward.
My lords.
So kindly apprise your client also. As it is, you have already taken enough problem, as it is. You have already taken enough problem. And at the fag end of the project, I think you should not take a U-turn, which will be adverse to you. See, okay, we'll give you time.
My lords.
We'll give you time. But where is the affidavit on the basis of that affidavit, which you have filed this morning?
Yes, Lordship.
So
I have sent for it, madam. I have sent for it.
okay, after some time, on the basis of that affidavit, will pass order, will give you time to sit and to discuss something very meaningful.
Lordship.
Lordships.
Okay?
My lords.
Okay.
For admission, item numbers 2 to 35.
Yes, ma'am, yes, ma'am.
I'm bearing on behalf of my senior.
Okay.
legal counsel, counsel for the petitioner. She is indisposed and I have been instructed to seek 2 more weeks time, Your Lordship.
To seek for the instructions.
Yes, Your Lordship.
Okay,
Lordship.
MS, your good name?
Lorena.
MS Loreno.
Yes, Your Lordship.
Learned Counsel makes a mention on behalf of MS Nito Koza, the Learned Counsel for the petitioner, and seeks adjournment of the case for 2 weeks' time to obtain further instructions from the petitioner. Prayer is allowed, listed accordingly.
Much
Okay.
obliged, Your Lordship.
Yes.
Obliged, Lordship.
Item. Okay.
Up to
Yes,
item 35. Up to item number 35.
I-
2 to 35.
2 to 30, yeah, item 1. Yes, Mr. Joshua, the affidavit has come.
Perhaps my lords would be
Yeah.
interested in paragraph 7, my lord.
Paragraph 7 of this, you have received a copy?
Yes, your lordships.
You have already issued. You have issued,
Yes, Lordship.
then,
Invited NIT, Lordship, we have.
Ah,
issued it.
that's why.
Lordship.
If you have invited NIT, then
It has not opened, Lordship.
heard Mr. A. Jimomi. Learned amicus curie. Okay, chronologically, respondent number. Let us see respondent number, how many respondents? 1,
Lordship, I'm representing 1, 2, and 8.
1, 2, and 8.
Lordship.
Mr.
James Song, I believe.
1, 2, and 8.
Mojami.
Yes, Mojamir.
Mr. Mua Jamir,
Next is.
learned standing counsel.
Engage counsel for.
Learned counsel for the learned counsel for the NHIDCL respondent number 1, 2, and 8. Mr. Three, 4, 5, 6, 7, 11, and 12. Mr. Im Song, the learned additional AG for the respondent number 3, 4, 5, 6, 7, 11, and 12. Mr. Joshua,
9, my lord.
learned counsel for the respondent, for the contractor respondent number 9,
And I'm for respondent number 10, Lordship.
and last respondent,
Yes, Lordship.
and Mr. Sintianger, the learned counsel for the respondent number 10. This affidavit on behalf of respondent number 2 and 8. 2 and 8 NHIDCL.
Lordship.
Okay. We have perused the affidavit dated 4/9/2024, filed by the respondent number 2 and 8. Stop. Paragraph 7 of the affidavit reads as follows. Okay. Okay, para 7. We are, however, of the view that before allowing the respondent number 2 and 8, that is NHIDCL, to complete the tender process. For maintenance and safety works by a third party. The respondent number 2 and 8 and the respondent number 10. Mr. Joshua, respondent number 10, contractor.
Respondent number
Nine.
9, Lord.
And the
Nine.
respondent number 9, contractor, should be given an opportunity to deliberate on the issue of the NHIDCL inviting tender for maintenance and safety works. Since as per the affidavit submitted by the Mr. Santi,
Respondent number
Respondent
10.
number 10.
Respondent number 10.
as per the affidavit submitted by
Authority engineer.
respondent number 10. That is the authority, since as per the affidavit dated
28 August.
28/8/2024,
Yes, Lordship.
filed by the respondent number 10. The contractor, the physical progress of the work is 74.23% and financial progress is 72.13%. We stop accordingly direct the respondent number 2 and 8 not to open the tender till the next returnable deed, so as to give an opportunity to the respondent number 8, 2 and 8, as well as to the contractor to find out whether any amicable solution can be arrived in the interest of the public. Okay? How much time?
Here, my observation is here, this is a PL, unlike other petition. So any party intending to do further step, it has to be done within the knowledge of the court, because it is a purely PL. Public interest.
Okay,
litigation.
we'll come to that because
Yes.
now for the timing, we have stopped the tender process.
No, it has to be within the knowledge of the court, only party has to move.
That's why I'm saying we have
Yes.
stopped the tender process, so let us see, let us give them an opportunity. Yes,
May we be granted 3 weeks, your lordships?
yes, we give you time, but on the next date, you place your discussion in the form of an affidavit
My
so
lords,
that it can be on record,
your lordships.
whether either it is feasible or not.
My lords.
And if actually there is no result out of the deliberation, then we will have to hear the petition on merit, the application,
My lords.
okay?
Lordships.
In terms of the agreement executed between the parties,
My lords.
okay? What was the last line, man? So there it is. Listed on. We listed on 25th. Okay, I think sufficient time. We have stopped. We said, no, don't open the tender till the next returnable date. Pardon? Okay, it's all right. We, on the next date, we will actually pass directions, but till then, don't open the tender. Listed on 25.
My lords.
Listed on 25, 9, 20, 24. On the next date fixed. The respondent number 2 and 8, as well as the respondent number 9, shall file affidavit bringing on record the discussions met between the parties. Okay, please bring it on record.
My lords.
Your lordships, the respondent 10 also to file a status report, latest status report on that date.
Who will file?
Respondent number 10, the authority engineer.
The respondent number 10 shall on the next date also file the up-to-date status report of the project. Okay.
Much obliged.
Yes.
Much obliged, my lords.
For admission, item numbers 36 and 37.
Yeah, Mr. Lordship.
Yes.
Lordship, I've taken the consent of the petitioner's lordship.
Yes.
If I may be granted 4 weeks' time, lordship. Here, I'm supposed to file an affidavit with regard to the school-based program for menstrual hygiene.
You are for respondent number, Mr. Mazui, 3.
3 years, lordship. National Health Mission, because the programs comes under my mission, lordship.
Yes. What is your prayer?
4 weeks' time may be granted, lordship. I've received some
To file
instruction.
affidavit?
Yes, lordship. I've taken the consent of the petitioner's
Okay,
lordship.
Mr. N. Mazui, the learned counsel for the respondent number 3.
3, lordship.
He is allowed 4 weeks' time
Lordship.
to file affidavit on the instructions received,
Lordship.
listed accordingly.
Obliged, lordship.
For admission, item number 38.
Your lordship,
Yes, ma'am.
I've been instructed. We'll be filing an additional affidavit. Kindly grant us 2 more weeks.
On behalf of the petitioner,
Yes,
On
on
behalf-
behalf
okay,
of my
ma'am.
senior Nitopozo.
the learned counsel, MS so the learned counsel for the petitioner is allowed 2 weeks' time to file additional affidavit, listed accordingly. Excuse me. No, ma'am.
For admission, item number 42.
So what? Yes.
Yes, please, Lordship, Lordship, there is a delay of 4 days in filing the instant appeal. And
I have no objection.
Yes, yes, why should you? Had MSV Sokri, the learned additional advocate general for the applicant. Stop. This application has been filed under Section 5 of the Limitation Act 1963 for condonation of 4 days delay in filing the connected read appeal. Ma'am,
Yes.
grounds for the delay?
Lordship, my grounds I've stated in page 3, para 3, 4, 5, Your Lordship.
The grounds for the delay has been explained in paragraph 3, 4, and 5 of the application. Stop. We have perused the application and we are satisfied that the applicant has satisfactorily explained the delay. The delay of 4 days is accordingly condoned. IA stands disposed. Where is that main appeal?
Lordship, I have a application for stay also.
Let us see the main appeal.
Lordship, here,
Wait. In view of the order, passed. Which IA we have passed?
104.
In IA civil number 104 to 2024. Appeal is admitted to be heard. Have you received?
The appeal I have not served to them, Your Lordship, only the condonation of delay application.
Okay.
Yes, I'll serve to them today, Your Lordship.
Issue notice to the respondents, returnable after 4 weeks. MS Lucino, accept notice on behalf of the respondent number,
Both the respondents,
in
madam.
respect of respondent number 1
1
and
and
2.
2.
Therefore, no formal notice need be issued to the said respondents. The Learned Government Advocate shall however serve the copies of the writ petition to the Learned Council for the respondent in the course of the day. Okay.
For hearing, item number.
No. We issue notice, we hear it on the next date.
Yes, Lordship.
Yes, heard. This is IA 105. Heard. MS. V. Socrates. Leonard. Additional AG for the applicants. The present application has been filed for stay of the impugned judgment and order dated 4/6/2024 was by this court in WPC number 22/2021. Issue notice to the respondents returnable after 4 weeks. MS Lucino appears for the opposite parties. Therefore, no formal notice need be issued. the learned government advocate shall however serve the copies of the application to the learned counsel for the opposite parties in the course of the
Lordship.
the application for stay shall be considered on the next return of the bill.
For hearing, item number 46.
Yes, the seniority 2018 was challenged only in the year 22. That is why your writ petition was rejected
Lordship,
on grounds of delay and laches.
Lordship,
What is your justification?
Lordship, may I take Lordship attention directly to the annexures, Lordship?
Huh.
To examine whether there is delay on the part of the writ petitioner in approaching the writ. Lordship, may kindly come to page 79 of the writ petition. Which it is the type copy, Lordship. By this command order, Lordship.
This is 2016.
Yes. The issue starts from the here, Lordship. By this command order, Lordship, both the petition, writ appellant and the respondents were promoted to the post of Assistant Lordship Subiram Vichir.
You are?
I'm C.D. Winkang, serial number 2.
You are, your name?
Serial number 2, Lordship, C.D. Winkang.
Huh. And he is the petitioner, and who is the respondent?
Serial number was T. Kisu Dikir. So by this command order, we were promoted to the post of Subiram Vichir, Lordship. And Lordship, may kindly come to page 81.
Page?
81, next page, Lordship. By this memorandum, Lordship, tentative seniority was published. This is dated for 10/9/2018. Lordship, may kindly come to page 83, seniority position. This is very modern, Lordship. Serial number 7 is the great equivalent. Lordship, on the fourth column, date of joining into government service. That is 27/7/2000. And date of promotion has rightly shown as 24/10/2016. And serial number 8 is the primary respondent number 7, Lordship. Date of entry into government service is 2001. Primary respondent entered into government service after 1 year after the appointment of the petitioner, and the date of promotion is on the same date, that is 24/10/2016. That is the tentative seniority list prepared in accordance with the seniority position of the petitioner and the primary respondent itself. Thereafter, Lordship, no final tentative seniority was published and I have not come across any seniority list apart from this seniority list, Lordship. What happened, Lordship? Surprisingly, page 85. This is notification dated 19 July 2021.
Yes, just read. You read your page 82.
Yes, Lordship.
The last line.
If no such objection is received within the stipulated date, seniority list as on 1/9/2018 will be the final.
So the provisional tentative seniority is made final in view of this memorandum?
Lordship, I'll come to that, Lordship, because by this seniority list, Lordship, tentative seniority list, I'm senior though, the brother respondent.
That is okay.
And after the seniority list, Lordship, the appellant never came across any tentative or final seniority list.
Just wait.
Before the brother respondent was promoted to the higher post by annexure by Beach 85.
Tentative seniority list. Tentative seniority list.
That is Beach 82, Lordship.
Ah.
I'm not agreed by this seniority list, Lordship. So when the matter does seniority Lordship, we kindly come to Beach 85. By this MBU notification, the brother respondent was given promotion to the higher post of assistant commandant. Serial number 3 is the brother respondent, Lordship, under recommendation of the Departmental Promotion Committee, Lordship. Therefore, Lordship, in order to ascertain the basis of recommendation of a junior officer for promotion, the petitioner filed an RDI. Page 85 is one of the impugn orders before the civil judge. One of the impugn orders. There are 3 impugn orders. Therefore, Lordship, on coming to know about the illegal provision of private respondent number 7, page 86, I submit a representation. Since no positive response, Lordship, page 88, RDI application was filed.
This representation is dated 12.
12. I've stated in my writ petition, Lordship. 12/9/22. Next page 88, Lordship. This is the RDI application. This is dated 13/9/2022.
13 or 12?
This is 12, Lordship. Received on 13. 12/9/22. And page 89 is the information furnished to the petitioner, Lordship. This is dated 3rd October 22. Till that time, Lordship, there was no information, knowledge about any tentative seniority list or the final seniority list issued after the earlier tentative seniority list. And page 90, Lordship.
No, what is a page 89?
9 is the documents furnished, which I saw through the RDI, Lordship. because I was in dark, the recommendation of the DBC, any seniority list issued subsequent to the tentative seniority list of 2018. Should be kindly come to page 90. This is the recommendation of DBC, by which respondent number 7 was recommended for promotion to the higher post. I may be allowed to read page 90, Lordship. This is very important. In order to ascertain whether there was any delay in approaching the grade court, Lordship. A meeting of Departmental Promotion Committee to consider the case of regular promotion of officers under Home Department was held on 15/7/2021 in the Conference Hall, Nagaland Public Service Commission. These are the members present. And next sentence, Lordship, this is very important. The Departmental Promotion Committee, after going through the seniority list, abars and service records as available, recommended as shown below. After going through the seniority list, which seniority list? I was not aware, Lordship. Therefore, Lordship, after getting this information through RTI,
Where is the promotion order of the respondent? Where is the promotion order of the respondent?
Lordship, promotion, page 85, Lordship. Only after getting the information from through RTI, Lordship, I discovered page 91.
So you were on an inquiry and investigation instead of approaching the court.
Lordship,
Good.
that is not a ground-up dismissal of my writ petition, Lordship. You kindly come to page 91, Lordship, for a moment.
Page?
Page 91. Because I was not aware the basis of recommendation of the BBC. Therefore, through the RDI application, I've received the basis of recommendation and subsequently, Lordship, page 91.
You were aware about the promotion. You were aware that your junior was promoted. You have actually seen the order.
Lordship.
Page 85. You had seen that order.
Yes, Lordship.
That's why I'm saying you were on a spree of inquiry and investigation
No,
instead of
Lordship.
approaching this court.
No, I've made a specific statement in my writ petition. How I challenge this promotion order.
You know the law. Repeated representation.
No, only one representation, Lordship. Only one representation. Therefore,
Your RTI is also a representation in the form of a representation.
Lordship.
You wanted to get the information.
Yes, Lordship. Because, Lordship, in order to challenge this recommendation promotion of the respondent number 7, it is the requirement that I should challenge the recommendation of the DBC also, which was not available to me. That is the reason why I obtained the recommendation through the RTI. And come to page 91, Lordship. This tentative senior, again, another tentative seniority list was discovered after the promotion of the respondent, Lordship. This is dated 30/11/2018. This tentative seniority list is also mentioned in the imbued judgment and order. 30/11/2018, Lordship.
Yes, where is your name?
Now my position has been reversed, Lordship. Page 92 is the type copy. Proper respondent number 7 is its serial number 7, Lordship. And my name reflected is serial number 8. And it appears that this tentative seniority list was the basis for recommendation of the respondent number 7 for promotion by the DBC.
Whether you have made any amendments that this tentative seniority list
Kindly come to my
was manipulated.
Lordship, it was not published. That was my statement. It was never published.
That will be your case, obviously.
So
That
what's
will
the
be your
merit?
case.
So far as the merit of the case is concerned, Lordship, this tentative seniority list, whereby the respondent number 7 has been shown senior, has been prepared on the basis of the joining date in the promoted post, Lordship. That is the statement made by the state respondent. Lordship.
No, it cannot be on the basis of the notification by which the respondent was promoted, because respondent was promoted only in the year 2001, 2021.
Yes, Lordship.
This notification can only be the outcome of this tentative seniority list, 15/9/2018.
Yes, Lordship. Promotion to the post of MDN promotion is in the year 2021, and this tentative seniority was issued on 30/11/2018.
That's 15/9.
15/11, Lordship.
As on 15/9/2018.
Yes.
So what is wrong?
This is a duplication of the earlier tentative seniority list, Lordship, which I referred to earlier, Lordship, page 82. Page 82, Lordship. Page 82 and 91. 91 is the application of this tentative seniority list. Only the seniority position has been changed, Lordship. Therefore, Lordship, my writ petition was dismissed.
Maybe it was on the basis of the appointment where actually the respondent was shown ahead of you.
Not appointment, date of joining to the promoted post, Lordship. That is the stand of the government. Taken before the Limited Civil Judge. However, those merit of the case was never discussed, Lordship, by the Limited Civil Judge, and dismissed my writ petition only on the ground that there is a delay and approaching the court and challenging the tentative seniority list of 30/11/2018. That is page 91. That is the reason for dismissing my writ petition by the Limited Civil Judge.
This is not tentative. Page 91 is not tentative.
In the heading, it is.
It is heading, but the body of the body of the memorandum. Final common seniority list of superior major of all districts under village guard organization is prepared and encloses annexure 1.
That is why, Lordship, I've questioned the legality of this seniority list before the Limited Civil Judge. This seniority list was come to the knowledge of the writ petitioner, Lordship.
That is always the case of the petitioner, always. You will sit over the seniority list and then you will let time pass afterwards. When it comes to the court, you will say that this was never published, it was never brought to our knowledge.
Lordship, we can consider circumstances, Lordship. Well, Lordship, we can come
You are in service. You are in service. You should be well conversant with your service particulars.
Lordship, we can come to my writ petition.
You cannot sleep and do your service.
No, Lordship, it's not that, Lordship. Lordship, we can come to my writ petition.
This is a final seniority list. This court will take cognizance of this.
Lordship, may kindly inquire from district respond whether this was published in accordance with law. To enable all the employees to know about this seniority position, Lordship. Never published. That was my case, Lordship, before the legislative judge. Page 45 is my writ petition, Lordship. And come to paragraph 11.
We have a limited number of home guards, village guards. So ADC and ex officio assistant commandant VG Meluri for deputy commissioner, every head of the village guard was informed.
Lordship, this.
And you are not challenging the first tentative seniority list.
No,
Even
Lordship,
first.
that's in my favor.
Yes, that is why. That is also not published. How can you appropriate and reprobate?
No, Lordship.
One which is in your favor, you say that is okay. The other one also, which is similarly published, you say that is not okay.
Lordship,
How can you take such a stand?
Both tentative seniority was issued in the year 2018, Lordship. After issuing the first tentative seniority list, Lordship.
The first also was not published, if we had to go by your submission.
Lordship.
The first also was not published. Okay, what is your next round?
Lordship, you can come to my writ petition, my statement. Page 45 is my writ petition. Come to paragraph 11, Lordship. Paragraph 11 is at page 64. I'll refer for paragraphs. May I read, Lordship?
Yes.
That the petitioner begs to state that since the petitioner was in dark, the basis of recommendation by the Departmental Promotion Committee TBC for promotion of the respondent number 7 without considering the petitioner who is senior to respondent number 7, information under RTI, the information has been sought from the authorities on 12/9/2022 through one Jingai Kenya. Pursuant to the RTI application, the respondent authorities filed later this year also furnished the minutes of the meeting of the TBC held on 15/7/2021. It is ascertained from the said minutes of the Departmental Promotion Committee that the recommendation was made based on the seniority list of bars and service records of the superior nature. Paragraph 12. That the petitioner begs to state that after receiving the minutes of the Departmental Promotion Committee through RTI, the petitioner and inquiry from the department was surprised to discover a seniority list of superior major allegedly issued by memorandum dated 30/11/2018. In the said seniority list, the name of the respondent number 7 is reflected in serial number 7, showing the date of last promotion and date of joining to the boss of Sweden as 25/10/2016. Whereas the name of the petitioner has been shown below respondent number 7 as serial number 8, and the date of promotion and date of joining is shown as 26/10/2016, although they were promoted by command order dated 24/10/2016. The petitioner has been informed that the said seniority list was placed before the Departmental Promotion Committee and accordingly recommendation was made based on the said seniority list. Paragraph 13. That although the copy of the imbued memorandum dated 30/11/18 has been shown endorsed to Commandant VG to Isang to circulate the same to all the superior major under the establishment, the petitioner neither received the memorandum nor is available under the establishment of Deputy Commandant VG Monkilde. The petitioner has reasonable apprehension that the said imbued office memorandum dated 30/11/18 has been prepared with vested entries and the same has been given undisclosed at the Commissioner Office Kohima, based on which the Departmental Promotion Committee considered the case of the respondent number 7 for promotion to the higher post of assistant commandant. The imbued memorandum is therefore prepared illegally, for which the same is liable to be citizen request. Last paragraph, paragraph 17. Page 19, page 69, paragraph 17. That the petitioner begs to state that memorandum dated 30/11/2018 was never served to the petitioner, and the petitioner discovered the said memorandum dated 30/11/2018 for the first time only in the last week of October 2022. As such, the petitioner had no opportunity to raise any objection, as he was in doubt about the seniority position reflected in the uncirculated seniority list. Therefore, such action of the authorities is liable to be interfered with by setting aside and quashing the imbued memorandum dated 30/11/2018.
Okay, that is your submission.
Writ petition was filed on 10/11/22. Lordship, may kindly consider one aspect, Lordship. Had the petition appellant knew about the seniority position reflected in the imbued tentative seniority list of 2018, where his name has been shown below the respondent number 7, he should not give mum, Lordship. Because by this memorandum, Lordship, his right has been taken away. And before October 2022, I cannot explain the delay. Because for the first time, I came to know about this memorandum only in the month of October 2022. And the writ petition was filed in the month of November, Lordship.
Say, Mr. Wati,
Yes, Lordship.
you already had the knowledge of the impugned promotion order that was issued in the year 2018. You were doing some soul searching exercises, wasting your time.
I came to know about the promotion only in the month of February 2022, Lordship. That is what I have stated in my petition, also. In the month of February 2022, I discovered the promotion order. And thereafter,
You are all in service. How does the promotion of the respondent escape your knowledge?
Lordship, you can consider one aspect. I am posted under MON. And from the date of appointment, I have been posted at Pongjing village, bordering to Myanmar. Therefore, Lordship, the notifications, the promotion of respondent number 7, who was serving at Peg, Lordship. I was not aware about the promotion of respondent number 7, who is working at Peg, different district, Lordship. Not in the same establishment at Mall. It's a home guard organization, Lordship. And I'm
Home guard or village guard?
Village guard, Lordship. And
small organization.
I'm posted at Pongjing village, that is bordering to Myanmar, Lordship. So all this aspect required to be considered by the legal single charge. However, Lordship, without considering the illegalities committed by the authorities and the version of the tentative seniority list and promotion of rebel respondent, my case was dismissed only on delay ground. I've just referred to the paragraphs in the writ petition, Lordship. It is my specific case that I came to know about the imbued tentative seniority list only in the month of October. Before that,
What
Lordship,
about the
how can I explain?
impugned promotion?
It was discovered only in the month of February.
Let us see the impugned promotion. Let us see. Let us see the impugned promotion order.
Page 85.
Yes, this was published in the official gazette, also Nagaland Gazette. It was not something which the department had did it hiddenly or discreetly. We'll resume after 5 minutes.
Provision đấy anh ra.
That's the one. I mean, money law, api.
Petrol 30 paisa per rate per living here. 30 paisa to 20 liters and maybe 50 liters and maybe kiman extra na. Ano ba?
나가면 되게 크게. 삼대라서. 아직 뭐 그것도 다른. 야, 너희 뭐라 그러나? 가서 봐라 그래. 아, 가만보라. 네. 인내되시나? Work. I don't know. What does it mean?
Okay. Başkenti.
I'll take only 10 minutes, Lordship.
Yes.
Lordship, so far as I'm concerned, there is no deliberate delay alleges on the part of the writ petitioner in challenging the tentative seniority list dated 30/11/2018 because that seniority list was come to the knowledge of the writ petitioner only in the month of October 2022. Secondly, Lordship, admittedly, the appellant is senior to the probable respondent number 7. Admittedly, I'm senior, Lordship.
See, let us see this order, page 79,
Lordship.
page 79.
Yes, Lordship.
Here, for promotion to the post of Subedar Major.
Yes, Lordship.
Respondent is shown on serial number 1.
Yes, that is not the seniority position, Lordship.
No.
That's the serial, Lordship.
If you were a senior, they could have shown your this thing.
What about the tentative seniority list prepared subsequent to the promotion, Lordship? That page 83. That is after the promotion. Page 83. I'm senior by 1 year, Lordship. Page 83. I enter into service in the year 2000, whereas respondent number 7 enter into service only in the year 2001. Therefore, Lordship,
when was the writ petition filed?
Writ petition was filed on 10/11/22.
10/11/22.
Lordship. The issue before the London single judge was the determination of seniority between the petitioner and the respondent number 7. However, instead of deciding the issue of seniority, Lordship, my writ petition was dismissed on technical ground of delay, Lordship.
Delay is one of a very important grounds
Lordship.
in a writ petition.
I'll place the citation later on, Lordship. For a moment, Lordship. The illegalities committed by the respondents may kindly come to page only one document, Lordship, page 154, Lordship. This aspect was not considered by the London single judge. This is the proposal for promotion, Lordship. Proposal for promotion to the boss of assistant commandant under vigilance guard, under village guard organization. In continuation of this development proposal, I am directed to forward herewith the requisition for developmental promotion duly filled in for promotion by the vacant post of assistant commandant PG, Nagaland under Nagaland village guard organization, along with necessary required documents for further necessary action. What are the documents furnished before the DBC, Lordship? May kindly come to page, this the continuation, Lordship, page 159. This is the ABAR submitted to the DBC. Serial number 2 is the appellant. No remarks, nothing, Lordship. No remarks, nothing. This was placed before the DBC for consideration of my case for promotion, not only the seniority. Blank remarks. CD Wingang, serial number 2 is the petitioner, appellant, Lordship. No remarks, nothing. In continuation of
What is this date of regularization in the present grade? Statement showing the particulars of officials under village guard organization for promotion to the post of assistant. So this is from what post to promotion is from?
From Subedar Major to assistant
So
commandant.
in the Subedar Major post, the petitioner was regularized first, at least one day before you.
No, Lordship.
See the date of regularization in the present grade.
On the same day, I have already referred to Lordship. Both of them, the appellant and the respondent 7 was promoted on the same day by the same order, Lordship. I'm referring this documents to show that the remarks in the service book, Lordship, apart. No remarks, nothing. Both bad, excellent, nothing mentioned here, Lordship. So this was placed before the DBC in order to deny my promotion, Lordship. And page 162, Lordship, same thing. 162. Lordship, kindly look, serial number 2, this, the appellant, no remarks, nothing. And the DPC considered this remarks in my upper lordship. However, lordship, the learned single judge failed to examine all these illegalities.
In that case, we have to refer back.
That is what a lordship. Instead of considering all this aspect, my writ petition was dismissed on technical ground.
Otherwise, you receive the DPC report every year. So there is no remark here in the DPC.
No remark, lordship.
Otherwise, you have received the DPC report every year.
Yes, lordship. By filing the additional affidavit by the government, there's remarks in my is here. I have included this part of record. May you kindly come to page 165. This is the affidavit filed by the state respondent. In terms of the direction of this honorable court, page 165 and 166. Here, there is remarks. This was not placed before the DPC. Therefore, my case before the learned single judge was the entry remarks in my ABAR issue was never communicated to me, which was considered by the DBC. And I relied the judgment of the third case lordship 2008 ADCC with regard to non-communication of ACRs. All these aspects, pertaining questions was ignored by the learned single judge and decided the case on technical ground.
Mr. Chiba, why this was not placed before the DPC?
My lord,
DPC, so far as the petitioner is concerned, appellant is concerned, nothing is mentioned.
my lord, I'll justify my submission, my lord, here.
No,
Because,
no, as per the record, nothing is shown here.
My lord, here it's like this. Notice was issued on 1st April 2021 to produce the APAR, and that those who are in due promotion to the post of assistant commandant. So the respondent has issued a notice to submit the APAR. In the notice was issued on 1st April 2021, but the petitioner has not submitted the APAR.
Notice issued
To all the incumbent who are due to promotion to the assistant commandant.
The APAR is supposed to be in the custody of the person who are in the line of promotion?
No, first, since the petitioner is working under the deputy commandant MON, so notice was issued to the commandant MON and to submit the APAR of the petitioner. Though in the list, but others have submitted, except the petitioner has not submitted the APAR. So before the DPC was seated, opportunity was given to the petitioner to submit. Since he has not submitted, he's in the list. Your lordship had seen that in the remark there's nothing because petitioner has not submitted. Opportunity was given to the petitioner to submit the APAR.
Okay, we'll come to you. We'll
Yes,
come-
my lord.
Yes.
I'll justify, my lord.
Hmm.
So,
Yes.
lordship, my case before the single judge was the remarks in my service book, the greetings, which was never communicated to the petitioner, was considered by the DPC. which is embellished.
DPC has never considered.
This was placed.
Yours is blank.
Lordship, may kindly see the recommendation of the DPC? Recommendation of the DPC, Lordship.
Where is that?
Lordship. Page 9D, Lordship.
What about page 162?
Yes, Lordship, this documents was placed before the DPC by the department, Lordship.
This page 162 shows that your APAR was never placed.
No, Lordship. Blank remarks.
That's why.
It is the duty of.
That's why you have not submitted. That's why it's blank. And the government has just
my
specified.
service book is in the custody of the respondent, not with me, Lordship. Our service book should be written by the person concerned.
No, but you were notified to submit the APAR.
No,
Anyhow, let us, yes, make your submission. Make your
yes,
submission.
Lordship. Therefore, Lordship, all this illegal action was not considered by the learned single judge. There is arbitrariness, discriminatory under recommendation of the DPC, Lordship. And instead of deciding all these illegalities, my case was dismissed on technical ground, Lordship.
Not only on technical ground, it was dismissed for delay in laches.
Lordship, so far as the delay in laches.
And
Lordship,
the
is
judgment of the Supreme Court, the lay down law. That if you are aggrieved by the promotion or seniority, you have to approach within 6 months.
Lordship.
That
Each
is
case
clear.
has to be decided on the given facts of that particular case, Lordship, taking into consideration of the merit of the case. I'll place your judgment, Lordship.
It may not be necessary to decide the merit when actually your case is hopelessly barred by limitation.
Lordship, may kindly allow me to refer only for
Yes.
judgment, Lordship. Lordship, with regard to delay.
That should be in the context of the present case. Delay, principle of delay laid down by the Supreme Court is okay, but it should be in the context of the present case. Let us see.
Lordship, before I refer the judgment, kindly come to the immune judgment. How my rate petition was dismissed.
I have seen.
The legislative judge referred to a judgment rendered by the Supreme Court, and based on that principle, my case was dismissed. Lordship, firstly, Lordship, first decision 2012 3 ACC.
Yes, give us the
2012 3 ACC.
No photocopy. This is the problem.
I've given Lordship list of books. 3 ACC. 7
Where is that list of books?
Only the relevant portion 2012 3 ACC 727.
Yes.
Lordship, may come to paragraph
2012. 2012?
3 ACC.
2012 3.
Yes. 727.
2012 3. Okay.
I'll take your Lordship directly to the relevant paragraphs, paragraph 47 and 48, page 755. 755, Lordship.
75. Okay.
Paragraph 47, subparagraph Lordship, paragraph 11. Therefore, the question is one of the discretion for this court to follow from case to case. There is no lower limit and there is no upper limit. A case may be brought within the Limitation Act by the reason or for some article, but this court may not necessarily give the total time to the litigants to move this court under Article 32. Similarly, in a suitable case, this court may entertain such a petition even after lapse of time. It will all depend on what the breach of fundamental rights and the remedy to claim are, when and how the delay arose. 48. The issue of the opposite decision is that even though there is no period of limitation for filing petition under Article 32 and Article 226 of the Constitution of India, the petitioner should approach the court without loss of time. And if there is delay, then cogent explanation, this important explanation, Lordship, cogent explanation should be offered for the same. However, no hard and fast rule can be laid down, or a straight jacket formula can be adopted for deciding whether or not this court or the High Court should entertain a valid petition filed under Article 32 or Article 26 of the Constitution of India, and each case must be decided on its own facts. And another decision, the second one, 1998.
This is what volume 1919.
Second one, Lordship. 1998, 8 ACC.
Which para?
685.
Which para?
Only two paragraphs, Lordship.
Yes, you have not given para, so I'm asking you.
I'm sorry, Lordship. Short judgment, paragraph 1 and 2.
Paragraph
1, 2.
1988.
1998, ADCC.
88, 685. Okay.
685, as Lordship had it. May I read, Lordship? The respondent was temporarily appointed police constable. He was posted at the residence of one honorable judge of the Allahabad High Court, Ascot. There was a written complaint by the single learned judge about the misconduct committed by the respondent. A disciplinary inquiry was held. The inquiry officer recommended that the respondent be removed from service. At that stage, instead of posting final orders in the state disciplinary proceeding, an order of termination, solicitor was passed under so rules 1975. An appeal was preferred by the respondent against the state termination before the Public Service Tribunal. The tribunal held that to unconscious inform and truth, the order was penal in nature. Accordingly, the responding blame petition was allowed and the order of termination was set aside. 1.5 years later, the state filed a writ petition in the High Court against the judgment of the tribunal, which was dismissed on the ground of delay. The High Court observed that there is no proper explanation for delay in filing writ petition. After 1.5 years, the present SLB is directed against the said order of the High Court. In our opinion, the approach of the High Court is not justified. There is no time limit for filing the writ petition. All the court has to see is whether the laches on the part of the petitioner are such as to entitle him to the relief claimed by him. But the High Court appears to have examined the matter as if it was a case under Section 5 of the Limitation Act 1963. Apart from the above, we do not think that the proceedings should be prolonged any further. Even if the tribunal is right in its opinion, the only result would be that the disciplinary authority would be now required to post final order in the disciplinary proceeding, having regard to the nature of the charges and having regard to the facts that the respondent was only a temporary employee. We think that the following orders would be an appropriate one in the circumstances of this case. The state of Palestine so the tribunal respondent shall be entitled to. That's not relevant.
Okay.
And third, Lordship, third citation is 1983 to ACC 1.
What is the paragraph?
Only one paragraph.
Yes.
Paragraph 1. Paragraph 1. Very Lordship. We are of the view that so far as writ petition under Article 226 of the Constitution is concerned, there is no hard and fast rule of 90 days by way of a period of limitation, but the general rule of laches alone can be applied, and this must necessarily be depend upon the facts and circumstances of each case. The High Court has said in this order that writ petition was beyond time by 136 Neither the explanation of 136 nor the explanation of filing a todi was given. This view does not appear to be correct because the High Court has not proceeded on the assumption that there is a period of limitation of 90 days, and unless sufficient cause is shown, as contemplated under section 5 of the limitation, a writ petition filed after the expiration of 90 days is liable to be rejected. This assumption is wholly unjustified. There is no period of limitation prescribed by any law for filing a writ petition under Article 226 of the Constitution of India. It is in fact doubtful whether any such period of limitation can be prescribed by law. In any event, one thing is clear and beyond doubt that no such period of limitation can be laid down either under rules made by the High Court or by practice. In every case, it would have to be decided on the facts and circumstances whether the petitioner is guilty of laches, and that would have to be done without taking into account any specific period of limitation. There may be cases even short delay may be fatal, while there may be cases where even long delay may not be evidence of laches on the part of the petitioner. We would therefore set aside the order of the High Court and remand the writ petition to the High Court so that the High Court may dispose it of on merit in accordance with law. Accordingly, allow the appeal set aside the judgment and order of the High Court and direct the writ petition may be disposed of by the High Court on merit in accordance with law. There will be no order as to us. Worship, as I've submitted. On merit, I'm senior, and Worship have sent the illegalities committed by the authorities and placing the documents before the DPC. Therefore, the learned single judge ought to have decided the intersectionality between the writ petitioner and the respondent number 7. However,
without deciding the question of delay.
So far,
you mean to say that the High Court single bench, learned single bench is barred from deciding the question of delay?
Because I've given explanation how I approached the.
Where have you stated in your paragraph? How have you explained? Let us see in your writ petition.
Lordship.
In your writ petition, where have you explained the delay? Let us see.
Lordship, paragraph 10, 11, 13, and 17.
Of your writ petition. Let us see once again.
Yes, Lordship. First, we kindly come to the writ petition, page 45.
Page 45.
My statement starts from paragraph 10.
Para 11,
Start from para 10.
Para 10 to?
Para 10, 11, 12, 13, and 17. Nine also important, Lordship. 9. I've stated how I come to know about the promotion order. Paragraph 9 also.
Okay.
Last citation, Lordship. Last. 1974. One is CC 317, paragraph 10.
This is the Trilokchan.
No, Lordship. Ramchandra Shankar, Dudar. 1974. Yes. Paratan. Only one paragraph.
What about the others? 2012 5 GLT.
That is on merit, Lordship, seniority. Huh? Yes, Lordship, that is with regard to seniority, Lordship.
So we have only 4 citations.
Yes, Lordship, so far as delay is concerned. The remaining citation is covering that the seniority.
Paratan.
Paratan. Page 3 to 5.
Yes.
May I read, Lordship? The first preliminary objection raised on behalf of the respondents was that the petitioner were guilty of cross-laches and delay in filing the petition. The divisional cadre were created as far back as November 1, 1956 by the government resolution of that date, and the procedure for making promotion to the post of deputy collector on the basis of the individual select list, which was necessary consequences of the creation of the individual divisional cadre of the Mamladar. This had been an operation for a long number of years. At any given effect to at any rate from April 7, 1961, and the rules of July 30, 1959 were also did not file the petition. Also, given effective since the date of their enactment, and yet the petitioner did not file the petition until July 14, 1969. There was a delay of more than 10 or 12 years in filing the petition since the accrual of the cause of complaint, and this delay contended the respondent was sufficient to disable the petitioner to any relief and a petition under Article 32 of the Constitution of India. We do not think this contention should prevail with us. In the first place, it must be remembered that the role which sees that the civil court be not inquired into the beliefs and state blame is not a role of law, but a role of practice based on sound and proper exercise of discretion. And there is no inevitable role that whenever there is delay, the court must necessarily refuse to entertain the petition. Each case must stand on its own facts. The question, as pointed out by Suiso, CG Suiso, and Suiso Lordship, or to follow from case to case. There is no lower limit and there is no upper limit. It will all depend on what the breach of fundamental rights, and the remedy claim are and how the delay arose. Here the petitioners are informed by the commissioner or about divisions by his letter dated October 18, 1960, and also by the then Secretary of the Revenue Department in January 1961, that the rules of recruitment to the post of deputy collector and the reorganized state of Bombay had not yet been unified, and that the petitioners continued to be governed by the role of Hyderabad state and the role of July 30, 1959, had no application to the assumption that the petitioner were therefore justified in proceeding on the assumption that there were no unified roles of recruitment to the post of deputy collector and the promotions that were being made by the state government were only provisional to be regularized when unified rules of recruitment were made. It was only when the petitioner, Gabor Suesu, was decided by the Bombay High Court that the petitioner came to know that it was the case of the state government and that petition and that this was accepted by the Bombay High Court. That the rules of July 1930.
Okay, these are on its own facts and circumstances.
Yes.
Each
when
and
there is
every
breach of-
each and every case will depend on its own
Yes,
facts.
when there is
That is the
breach of
law.
fundamental rights, Lordship,
Yes,
the delay and decision should not be primary consideration.
we will see the facts of your case. Let us see how the other court, the other side will explain.
Yes, Lordship. Therefore, Lordship, my limited prayer in this great appeal, Lordship, is that the immune judgment and order dated 24/4/2024 is totally elected. And the learned single judge ought do have considered my case with regard to determination of seniority and the arbitrary competition made by the promotion committee. Therefore, Lordship, the impugned judgment noted 24/4/2024 is liable to citizen quash, and Lordship may kindly remand the case to the learned single judge to decide my writ petition on merit. Lordship.
Okay. Yes.
May I please lordship.
Yes,
My lord, I'll make it very precise and simple. My lord, may I, my lord? My lord, notice was issued on 1st April 2021 to the petitioner to submit the APAR.
Ah.
And the TPC was stated on 15/7/2021. And the order was out, the session was taken on 19/7/2021. So, my lord, after, as per the submission made by the petitioner says that the TPC, the decision was came to know by the petitioner only in the month of February 2022, as per the delay explained in the petition. But representation was submitted only on 12/9/2022. So there is a delay of 1 year, 6 months. From the date of TPC. TPC was seated on 15/7/2021. And the representation was submitted on 12/9/2022. So why the TPC has not considered his case? Notice was issued, but the petitioner has not submitted his APAR. That is why the TPC could not consider his case. And secondly, my lord, 2018, the seniority list 2018 was challenged only on 10 November 2022. Writ petition was filed on 10 November 2022.
Mr. Tiba,
Yes, my lord.
why two same seniority list?
Earlier in first notification, in the notification, it says that 30 days was given to the incumbent. If there's any objection, they can file objection or submit a representative for notification. The private after issuing that circular, private respondent has submitted his representation, challenging that he should be senior to the petitioner.
Whether that application is enclosed?
That application is not enclosed here, but it was submitted. So basing on that, the authority has rectified the seniority list up to the.
Why seniority list is of the same date? Seniority list is of the same date.
Yes, it was rectified.
No, why same date? Well, if you are giving a 30 days time.
Yes.
The second seniority list should have been published after 30 days.
first seniority list was on 1583
Which is that page?
page.
Page 83.
Yes. Memorandum was issued on 14 September
This
2020.
is first seniority list, correct?
Yes,
This is first seniority list and the memorandum was issued on
14 September 2020, 2018.
14 September 2018.
Yes.
And the second seniority list?
Second seniority list,
Page 91.
page 91, 30 November 2018. This is the memorandum.
Just wait. First memorandum was issued on
14
September.
Yes, madam.
Okay, 14/9, okay. Yes. And
Second was 30 November 2018.
30 November.
Page 91.
Okay,
Yes.
okay. I have mistaken it. 30 November. Yes.
So there is a delay of more than 3 years, madam. So basing on this seniority list and the recommendation of the DBC, private respondent case was considered.
The first seniority list was published in the page 83 is 14/9/2018.
Yes,
And the second is
30 November 2018.
18.
Page,
Yes, 2018.
page 91.
91.
91A.
Why they changed?
Because in the earlier,
seniority?
in the first seniority list,
Ah.
private respondent was senior to the petitioner. So that is why the representation was submitted, objection was submitted by the private respondent to the authority to rectify that seniority list.
In the first seniority list, the appellant is
Senior,
senior.
yes.
And
In the rectified, the second one is the rectified seniority list.
okay,
There he is junior than the private respondent.
so why this? He filed application
Yes.
saying what?
So in the application, it says that by common order, private respondent and the petitioner were promoted by same common order.
Yes.
But date of joining in that boss
Ah.
was 1 day prior to the petitioner. Private respondent was joined 1 day prior to the petitioner. That is why the private respondent was placed above the appellant. Man.
Is that allowed?
Yes, my lord.
Because in the seniority, because this is continuation of the service.
Yeah.
And during the service only they were promoted.
Yes.
And then promoted in the promoted post. So the joining is counted again.
Yes, my lord.
How?
In the determination of seniority list, if they are
This is provisional seniority list. And This is the final seniority list. So in this provisional seniority list, it has to submit objection. If any with regard to the position, so submitted objection, thereafter this final seniority. In the promotional process. That is a disputed. We will first have to see whether. Let us consider.
so, my lord, the seniority list.
Okay, we resume at 2. Yes.
So, may I please, Your Lordship?
Yes.
So my humble submission is, petitioner has delayed more than 3 years to file the present writ.
Yes,
of
let
result.
us come to your affidavit. Let us see how you are making that submission. Let us see. You take us to the materials. Especially your affidavit before in the writ petition.
The writ petition. Page 93, Annex K.
Page.
Page 93.
Just wait.
Para 5, para 6.
Yes, wait.
Yes.
You read.
Para 5, my lord. May I read, my lord?
Yes.
That in regard to the statement made in para 5 of the writ petition is not denied. However, the answering deponent humbly begged to state that both the petitioner and the respondent number 7, who was also in the rank of Sabidar, then were promoted to the next higher post of Sabidar Major in the same order as claimed. The date and timing of joining the post is regarded as crucial owing to dispute arising out of seniority that used to rise after joining the service in the state of in the government institutions. As claimed by the petitioner, he submitted his joining as Sabidar Major on the 26th October 2016. However, the head of office, that is Deputy Commandant, had noted in the joining report itself quoted that accepted join on 1st November 2016, and the respondent number 7 had also submitted his joining report on the 25 October 2016 at 10 a.m. So the private respondent was joined 1 day prior to the petitioner. Para 6, my lord. May I read, my lord? Para 6. That in regard to the statement made in para 6, 7, 11, 12, 13, and 14 of the writ petition, the answering deponent pertinent to state that, as claimed by the petitioner, the tentative senatorial list of Sapitar Major was issued on 14/9/2018 in the form of the memorandum wherein any claims of objection, correction, or clarification were sought within 30 days from the issue of memorandum, which will be treated as final if there is no such objection. In response to the above said memorandum, the respondent number 7 submitted a self-explanatory representation seeking for rectification of the above said tentative senatorial list of Sapitar Major on 25 September 2018, stating that he is senior to the petitioner as per the joining report in the rank of Sapitar during 2016, as stated in para 5 above. Thereafter, the office of the commissioner, Nagaland, by letter dated 17/11/2018, had written to the deputy commandant Viji Mon to authenticate the joining report of Sri Siti Wengang Konyak, Sapitar Major Viji Mon, to which deputy commandant Mon has complied accordingly and submitted by letter dated 20/11/2018. Subsequently, by White Memorandum number 30/11/2018, the final common senatorial list of the Sapitar Major of all districts under village card organization was prepared and issued. Thus, the petitioner contention is just an act of frustration. His claim of never coming across the memorandum is imaginary and a lame excuse in view of the fact that he, being an officer in the rank of Sapitar Major and being in the same service and department, how come he is not aware of his service matter where he is serving? Para 7. That in regard to the statement made in para 8 and 9 of the writ petition, the answering deponent begged to state that admitted that the next line of promotional post is assistant commandant for Sapitar Major under the VGO. However, a service rule which is still in draft stage, namely Nagaland Draft Village Guard Service Rule 2014, is being referred to as a guideline for promotion to the next higher post of assistant commandant till finalization of the service rule. It may be pertinent to mention here in that senatorial list along with good APAR and integrity is also one of the mandatory requirement and component for promotions under every government institution. Hence, the contentions of the petitioner that there is no service rule governing the condition of the employees of the VGO and that promotions are effected basing on the general principle of seniority is misleading and untrue. The promotion of the respondent number 7 was initiated and given on the recommendation of the departmental promotion committee, basing on the record documents and certificates, seniority, list, APAR, integrity, vigilance, declarance. Hence, the contention of the petition of expecting promotion without any substance is amusing. Para 8. That in regard to the statement made in para 10 of the writ petition, the answering deponent humbly begged to state that the petitioner claim of not aware of the notification dated 19 July 2021 and mentioning posting at different place is just a unsubstantiated and unacceptable ground, since the said notification also include 2 incumbent officials who were posted at Mon, the place where he is posted.
What is this 19 July, Mr. Tiba? This is the promotion.
No, that is the
19 July 2021.
notification.
Notification of what? Promotion.
Seniority list. Seniority list. Oh, promotion. The DPC decision.
Also includes 2 incumbent officials who were posted at Mon.
Yes.
The place where the petitioner is posted.
Para 9, that in regard to the statement in para 15, 21, and 22 of the writ petition are denied. The answering deponent have pertinent to state that the action of the respondents were neither an illegal, arbitrary, discriminatory, nor contraventions of the Constitution of India. Rather, it was done in the interest of public service. The petitioner rights were not denied in contraventions of the existing norms of appointment, and justice was not done or denied to him, but rather given ample opportunities in the service by way of appointing and promoting him twice till date.
You have mentioned about APR, some APR?
Yes, APR.
Where is that statement?
My lord, that since petitioner has not submitted, and that regarding that that APR was submitted when the it was in the course of hearing, the petitioners has not submitted that issue was raised regarding
where
the submission.
have you stated that?
So in the affidavit, it's not there, but in the compliance affidavit.
Oh,
Compliance affidavit in the
Okay.
page number 165.
Where is that compliance affidavit?
Yes. 165. 165. This compliance affidavit was filed in compliance of Honorable Court Order dated 12/12/2023. During the course of hearing, the petitioner submitted that in the remark of the DPC, nothing has been mentioned. That is why court directed why there was no remark. So this is the compliance affidavit filed by the respondent.
Upper during consideration of the upper during consideration of this promotion.
Yeah.
So upper or DPC report is to be produced by the department only or before the committee.
That record has to be produced before the DPC.
No, it is to be produced by
Yes.
the department only.
Yes, department.
Yes, why the department did not produce there?
No, my lord, it's the facts is like this. Notice was issued to the head of the department where the
Head of the
petitioner was.
department did not
Yes,
produce.
yes, and it seems that that time the head of the department has informed the petitioner to produce the APAR because the APAR was with the petitioner.
No, no,
Because-
it is supposed to be with the department.
Yes, it is supposed to be with the
And,
department.
Yeah, department has to produce it.
Yes, but it was but the APAR was with the petitioner.
Now, how? The main, the document is with the department only,
Yeah.
in a book, in a service
So-
book. Service book is with the department only, not with the applicant.
Yes, service book is
A copy,
different.
of course, copy,
My
of
lord,
course, is
my
to be
lord,
given.
service book is different and the APAR is different.
Now, upper, during the upper is with the department, the main.
Yes, it should be in the department.
Hmm.
But that APAR was with the petitioner. That's why the department could not produce the
No, no.
APAR.
It is to be with the department only.
Yes,
The
but
copy
it is
given to
with
the.
the department. It
Yeah.
should be with the
So
department.
it is the duty of the department to produce before the DPC committee at a time of consideration of promotion,
Yes,
isn't it?
yes.
And after the second DPC, or sorry, after the second seniority list, whether the department has or has issued again another notice inviting objection.
Yes, in the notification is clearly stated in the
Okay.
second, in the notification issued on 13 November 2018.
Okay. So thereafter, nothing has come
Yes, your,
from the applicant.
yes, till the filing of writ petition, the petitioner was remained silent.
Hmm.
You have never approached the department to rectify
objection
the.
was invited. No objection was invited.
No, my lord, in the.
Can you see the
Second seniority list is at page 91.
Only in the first notification it is mentioned, my lord.
Okay.
Second one is the final, my lord.
Second one is the final. And then
Yes.
after publishing of this final, whether, just like in the first, whether it was invited to any objection or objection, age in the case of age, it was, if no such objection is received, so like that, it was not issued. It is not. After objection.
After objection, final seniority.
And then this, the appellant says that this is now not in his knowledge.
Yes.
Okay.
My lord, in the first notification, it is mentioned that those who have any objection
Yes, yes.
can file the objection within 30 days. Only the private respondent has submitted his application to rectify. So
Yes,
accordingly, it
and
was.
Mr. Gauhati, you are agreeable and you have no objection to the first provisional, there's a notification.
Yes, Lordship, because I'm senior in the seniority list. In the first seniority list, I'm senior. That is according to the.
Yes,
seniority.
that means that the final seniority list was published.
No, Lordship, not published. No record to show that it was published.
Even the provisional seniority list was not published.
Yes, my lord.
That's what I am asking. Okay, Mr. Thiba.
Yes, my lord.
You have stated that the APAR,
Yes.
the head of the department, where was the petitioner serving at that point of time?
Mon department, Mon.
You said that the APAR, the head of the department did not submit the APAR.
Yes.
Where have you stated that?
That one in the affidavit, it's not there.
Then?
In the affidavit, it's not there. But during the course of hearing, I've produced the notice.
Where is that notice?
Earlier, I've already produced before the board, my lord. But your lordship may kindly refer this later.
Where is that notice?
It's in the main writ petition, in a single bench matter, my lord.
This is that notice?
Yes, this is the notice given to the HOD. And this notice was issued 2 months ahead of TPC, my lord. Only the serial number 1 has produced the APAR, except the petitioner. The serial number 2 is the petitioner. Yeah. And since the serial number 1 has produced the APAR, his case was considered by the DPC. So, my lord,
So
if
just one, during 2016, after promotion, so at that time, where the petitioner, the appellant was posted?
Appellant.
2016.
Mon only,
Because
Mon.
there is a
He was
difference
in
of
Mon.
joining date.
Yes,
Only because
Mon.
of that.
He was in
he had
Mon,
been
my
placed,
lord.
huh? Both
Mon.
of them were in Mon, same district.
No, no, no.
Where?
Different place.
Hmm?
One is in the Kivri.
Kiviri. And
Yes.
then one is in Mon.
In the Mon, yes.
Where they were to join.
In the respected HOD office.
Where is that?
A commandant.
Where is that?
It should be before the commandant.
Commandant.
One in Kivri
Ah.
and one in Mon.
Because after promotion, it may have, because of distance,
Yeah.
one may not reach in a day.
But both are far from the Nagaland because in fact
So,
the
then-
Kivri is more distance than the Mon, my lord.
So that is why.
Yes.
Whether after promotion, whether the joining can be counted. Joining that can be counted for the purpose of counting seniority.
Yes.
Because he is already senior. So only because he could not reach on time, one day late, he reached. So can he be placed as a junior?
Because by common order in the post of
So
Sapita
date of
Major.
joining was given.
Yes.
No, whether the date of joining was specified.
No, my lord. No.
It was
So-
just because that comes under merit.
Yes. So, my lord, if the petitioner has agreed by the TBC decision, why he was remain
No, no,
for
in
more than 1 year
No,
to challenge the
in the
TBC?
First,
Yes.
since he was senior, already senior, he don't have to file any objection.
No, in the TBC.
Second, he says that he did not see
Yes.
after correction because the respondent submitted objection, not the appellant. And an appellant says that the objection submitted by the respondent was not known to him. And then thereafter, the publication of new seniority list was not known to him. That is what he said. That is, of course, in merit. But then,
My lord,
but then the objection.
My lord,
He is
he-
supposed to know. of
Yes,
course.
he is in the department.
Yes.
He is an officer. He should have known that because others have submitted same circular. It was circulated to the different place under the different place like Mon, Dunsang, Long Lang, and others, those who have come across that circular, they have submitted that the private respondent has seen that circular and submitted the objection. But the petitioner, he was remained silent. He did not say anything. And after that final seniority list also, he was remained silent until, and he said that the seniority list that rectified that final seniority was only he came to know in the month of February 2022. And he remained silent. He submitted representation on September, say. That one so. So,
Now
my
we are
lord, if
concerned- So in the writ petition, your basic challenge was against her?
Three impure orders,
Okay, one,
recommendation of DBC, promotion of the private respondent, that is 2021,
uh,
19/7/2021, and the seniority list, which
okay, seniority list where you have been placed below the respondent.
yes, which was discovered after the promotion of the private respondent.
so, my lord, I have relied one judgment. Your lordship may kindly see in 189, page number 189. It is reflected in the judgment, my lord. 189, para 9. (1976) 1 SSC 599. May I read, your lordship? Although security of service cannot be used as a shield against administrative action for lapses of a public servant, by and large one of the essential requirements of contentment and efficiency in public service is a feeling of security. It is difficult, no doubt, to guarantee such security in all its variety aspects. It should at least be possible to ensure that matters like one's possession in the seniority list, after having been settled for once, should not be liable to be reopened after lapse of many years of the instant of a party who has, during the intervening period, of chosen to keep quiet. Racking up all matters like seniority after a long time is likely to result in administrative complication and difficulties. It would therefore appear to be in the interest of smoothness and efficiency of service that much matters should be given a quickness after lapse of some time. So basing on the seniority list and the DBC, the respondent has considered the case of the private respondent. So challenging that consideration after a gap of more than 3 years is not acceptable. So my submission is there is no illegality in the judgment passed by the learned single judge. That is my humble submission, my lord.
Yes, Mr. Tongpok.
Your Lordship, I'll take your Lordship to one specific paragraph of my affidavit.
Just wait.
It starts from 125. Page 130. My affidavit starts from 125, but a relevant
Just
paragraph.
Your affidavit starts from
125. And then.
page 125.
Yes.
Just
but,
wait. Just wait. Just wait.
Yes, yes.
Page 125. 125.
Yes. Paragraph 8 encapsulates the issue of my objection on delay and laches, Your Lordship.
Just wait.
Yes.
Para
8. Page 130. If I may read, Your Lordship.
Yes, please.
That with regard to the statements made in paragraphs 13, 14, 15, 16, 17, 18, 19, and 20 of the petition. It is obvious that the same are contrived, being the consequence of calculated afterthought. It is difficult to comprehend from his statements the fact that among all the Subedar majors of the village guard organization, he is the only one who was oblivious of the existence of the memorandum dated 30/11/2018. That is the last final seniority list, Your Lordship. But of course, he was aware only about the existence of the memorandum dated 14/9/2018. He was aware about existence of the earlier memorandum, but he was oblivious about the final.
That is what this
That
court
is
has
what-
been inquiring.
Yes, yes. From his admission that he was at least aware of the existence of the memorandum dated 30/11/2018, no inference other than that he had no option but to acknowledge his such awareness purely to construct a foundation for filing the instant petition can be drawn. Incidentally also, from his statements, it can be inferred that till February 2022, he was unaware about the promotion of his immediate colleague, Sri L. John Konyak. This Sri L. John Konyak and him, they are posted together as superior major. And Sri L. John Konyak was promoted together with the instant respondent. He did not know about the other person who is with him, his promotion. That is what he is saying. Sri L. John Konyak posted at the same station as he, who was promoted together with a deponent by the same notification dated 19/7/2021. Here also, it is apparent that he had to construct a rough state of knowledge so as to build his case upon and to explain away the delay in approaching the Honorable Court. In his attempt to construct a broad narrative to justify his belated approach before the Honorable Court, he has created huge gaps that cannot be filled. His statements are not merely implausible, but absurd. Rather than support his case, his narrative only exposes his, to put it mildly, incompetency as a responsible officer of the uniformed service. His statements imply that he is totally oblivious of everything that is happening in the department. He is serving as an officer. This amounts to gross negligence. Lack of awareness due to negligence is no excuse. Even assuming, but not admitting that he was genuinely aware about the existence of the memorandum dated 30/11/2018, or came into knowledge about the notification dated 19/7/2021, only in the month of February 2022. Knowledge of the same from the very beginning must be attributed to him. It must be attributed to him. He is required to know what is going on in the department. Justice is served only to those who are vigilant. The petitioner is guilty of delay and laches in filing the instant petition. It is settled principle of law that the courts exercising public law jurisdiction do not encourage agitation of stale claims and exhuming matters where the rights of third parties may have accrued in the interim. The memorandum dated 30/11/2018 reflects the deponent in seniority above the petitioner. Had the petitioner been aggrieved, it was incumbent upon him to challenge the validity of the memorandum without any delay before any right accrued to the deponent. But he, having not contested the validity of the same, it became final. And in the interregnum, right having solidified and accrued the deponent was promoted to the next higher post of assistant commandant by the notification dated 19/7/2021. However, here it is reiterated that the promotion of the deponent having been considered in terms of the provisions of the Draft Service Rules 2014, seniority alone was not the sole criteria for the promotion of the deponent. As the record revealed, even the case of the petitioner and another officer who fell within the zone of consideration for promotion were considered together with the deponent. And based on the merit of the overall assessment, the DPC approved the promotion of the deponent. There is therefore no infirmity in the memorandum dated 30/11/2018 and the notification dated 19/7/2021. Then, after more than a year of the promotion of the deponent, the petitioner has preferred the instant petition, impugning both the memorandum dated 30/11/2018 and the notification dated 19/7/2021, citing ignorance as the sole ground for filing the belated petition, which is no ground in the eye of law. The petition being suffering from gross delay and laches on the part of the petitioner, the same is liable to be dismissed with cause. So there is deliberate negligence on the part of the petitioner. He cannot approach this honorable court claiming he was ignorant. If ignorance is allowed, Your Lordship, it will have no end. And he's an officer, responsible officer. And there are other officers similarly situated with him in the same place where they are posted. They have the seniority list when it is published. They also were promoted. He had no knowledge about the promotion. What was he doing? He was streaming. And he ought to have challenged the 2018 seniority list prior to the promotion of the petitioner in the first place. He did not do that. Even after the petitioner was promoted, even in the case of promotion of the petitioner, he ought to have challenged it at the earliest. But he waited for more than a year, almost 2 years, in fact, and approached his court, concocting all these stories. Now, he has not been able to explain away all this gross negligence on his part. He is only saying that I was ignorant. I am ignorant. Both of us are in the same boat. One is at Kifiri. Kifiri is farther and more, even the road accessibility is also more difficult at Kifiri. He is at Mon. He has not even explained. He's only saying ignorance, ignorance, ignorance. That is the position. Now, Your Lordship, in this respect, I would like to cite some decisions. First, 2008, 8 SCC, 2008, 8 SCC,
8 SCC,
648.
648 para.
Paragraph is 7. Relevant paragraph is 6 and 7, Your Lordship. 6 and 7. 6, the first part, I'll read.
Just wait.
If I may read.
Just wait.
6.
2008, 648.
Yes.
Tarsam Singhs.
Yes. Page 651, paragraph 6 and 7, I will read. 6, only the first portion which is relevant. If I may read, Your Lordship.
Yes, yes.
In Shiv Das versus Union of India, this court held, SCC page 277, para 8 and then 8. The High Court does not ordinarily permit a belated resort to the extraordinary remedy because it is likely to cause confusion and public inconvenience and bring in its train new injustices. And if writ jurisdiction is exercised after unreasonable delay, it may have the effect of inflicting not only hardship and inconvenience, but also injustice on third parties. It was pointed out that when writ jurisdiction is invoked, unexplained delay coupled with the creation of third-party right. Here, third-party right has been created. In the meantime, is an important factor which also weighs with the High Court in deciding whether or not to exercise such jurisdiction. Paragraph 7, Your Lordships. To summarize, normally, a belated service-related claim will be rejected on the ground of delay and laches, where remedy is sought for filing a writ petition, or limitation, where remedy is sought by an application to the administrative tribunal. One of the exceptions to the said rule is cases relating to a continuing wrong, where a service-related claim is based on a continuing wrong. Relief can be granted even if there is a long delay in seeking remedy, with reference to the date on which the continuing wrong commenced, if such continuing wrong creates a continuing source of injury. But there is an exception to the exception. If the grievance is in respect of any order or administrative decision which related to or affected several others also, and if the reopening of the issue would affect the settled rights of third parties, then the claims will not be entertained. For example, if the issue relates to payment or fixation of pay or pension, relief may be granted in spite of delay, as it does not affect the rights of third parties. But if the claim involved issues relating to seniority or promotion, etc., affecting others, delay would render the claim stale and doctrine of legis limitation will be applied. Insofar as the consequential relief of recovery of arrears for a past period is concerned, the principles relating to recurring successive wrongs will apply. As a consequence, the High Courts will restrict the consequential relief relating to arrears normally to a period of 3 years prior to the date of filing of the writ petition. It is very clear. If it is a case of seniority or promotion unless delay is explained. Here, no delay has been explained, Your Lordship. Now, another judgment, Your Lordship. 2011, 5 SCC 607.
607.
Yes, 607. 2011, 5 SCC 607.
Para.
The relevant paragraph is 54. It starts from the issue of delay and ledges.
Para 54?
Yes, 54 only will do, Your Lordship, but it starts from paragraph 46. Different decisions of this court has been discussed, and it has been summarized in 54. Starting from 46 onwards, regarding delay in ledges, what is the law on the point that has been decided by the apex court in various judgments, and then it is summarized in paragraph 54, Your Lordship. Page 629, paragraph 54. If I may read, Your Lordship.
Yes.
Page 50, paragraph 54. The relevant considerations in determining whether delay or latches should be put against a person who approaches the writ court under Article 226 of the Constitution is now well settled. They are, number one, there is no inviolable rule of law that whenever there is a delay, the court must necessarily refuse to entertain the petition. It is a rule of practice based on sound and proper exercise of discretion, and each case must be dealt with on its own facts. Number two, the principle on which the court refuses relief on the ground of latches or delay is that the rights accrued to others by the delay in filing the petition should not be disturbed. This is the case here. Unless there is a reasonable explanation for the delay, because courts should not harm innocent parties in their rights if their rights had emerged by the delay on the part of the petitioners. Here, right had emerged to the present respondent because of delay. Three, the satisfactory way of explaining delay in making an application under Article 226 is for the petitioner to show that he had been seeking relief elsewhere in a manner provided by law. In this case, even his representation was post the promotion of the petitioner. If he runs after a remedy not provided in the statute or the statutory rules, it is not desirable for the High Court to condone the delay. It is immaterial what the petitioner chooses to believe in regard to the remedy. 4. No hard and fast rule can be laid down in this regard. Every case shall have to be decided on its own facts. 5. That representations would not be adequate explanation to take care of the delay. So the law is very clear. He ought to have approached this honorable court or taken up the issue prior to promotion of the petition, the present respondent, in the case of the earlier seniority list. Now the last decision, these are also similar. This is 2015 1 SCC 347.
2015?
2015 1 SCC 347. Paragraph 20 and 21. Page is 362, Your Lordship.
Para 20
and 21.
Para 20.
Yes. Here the principles is discussed. The court also quoted the following passage from Halsbury's Laws of England. 12. In determining whether there has been such delay as to amount to latches, the chief points to be considered are, number one, acquiescence on the claimant's part, and number two, any change of position that has occurred on the defendant's part. So first is acquiescence. He acquiesced to the earlier seniority list. For more than 3 years, he was waiting. He was acquiescing with that. So based on that, I was promoted. There is acquiescence on his part. Then secondly, any change of position on the part of the defendant. Now, because of his acquiescence, change of position occurred in my case. I was promoted. So now he cannot reopen that the earlier seniority list. Acquiescence in this sense does not mean standing by while the violation of a right is in progress, but assent after the violation has been completed and the claimant has become aware of it. It is unjust to give the claimant a remedy whereby his conduct he has done that which might fairly be regarded as equivalent to a waiver of it, or whereby his conduct and neglect, though not waiving the remedy, he has put the other party in a position in which it would not be reasonable to place him if the remedy were afterwards to be asserted. In such cases, lapse of time and delay are most material. Upon these considerations rests the doctrine of laches. So in this case, this clearly explains the case, the instant case. 21. Holding that the respondents had also acquiesced in accepting the retirements, the appeal of UP Jal Nikam was allowed with the following reasons. In view of the statement of law as summarized above, the respondents are guilty since the respondents have acquiesced in accepting the retirement and did not challenge the same in time. In this case, the facts are different, but this is a case of, here in this case, it is also a case of acquiescence by the petitioner. 2018, the final seniority list came out. 19, 20, 21, 3 years, the Lordship. He knew of his existence because others who were there already with him, they also know it. Everyone knows about the seniority list. Only he is saying that he was ignorant. No explanation other than ignorance. He acquiesced. Now, 2021, because of his acquiescence, consideration was made, and even at that time, he was also negligent. Then after the petitioner is promoted, more than a year later, he has approached this court. Clear case of laches. It's negligence on his part, Lordship. He has not been able to explain it, except that he was ignorant, and ignorance cannot be. This honorable court in the earlier judgment has said that he should give clear explanation. If explanation should also be cogent. Like for instance, he should have been pursuing the matter. He did not. He was not pursuing the matter. Only after everything is completed, he has started the pursuit. So it is a case where this honorable court, the learned single bench was right in arriving at a conclusion that there is deliberate delay and laches on the part of the petitioner to approach this court. I am the third party involved here. And the third party is right. When my right is involved, he has to explain, he has to bring genuine reasons for approaching this court at this belated stage. So it is the learned single bench made no errors in dismissing
Let
the
us,
petition.
Mr. Tongpo.
Yes.
Let us see your statement where you have stated that the final seniority list was known by the other colleagues. Where have you made that statement? Who were serving with the petitioner?
Yes. In paragraph 6 also, your lordship will see.
Paragraph 6 of?
Yes, paragraph 6.
Of your affidavit?
Affidavit, yes.
Well, that is in page 125.
Paragraph
yes.
6 also, there are in fact 2 of them.
You are referring to paragraph 6
yes.
of your affidavit.
Yes, paragraph 6 of my affidavit. And
just wait. Para 6, correct?
And yes,
That is at page 128.
128, yes, paragraph 6.
128. Kindly
This-
read that. Let us
Yes, Your Lordship.
kindly read.
Yes, yes, yes.
Where have you stated that?
Oh, this is with regard to the promotion, with regard to the earlier one.
Para 8.
Yes, para 8. Para 8, I have clearly stated.
Para 8.
Para 8 is the one where I have clearly stated that.
Kindly read that again. Let us be very sure.
Yes. That with regard to the statements made in paragraph 13, 14, 15, 16, 17, 18, 19, and 20 of the petition, it is obvious that the same are contrived, being the consequence of calculated afterthought. It is difficult to comprehend from his statement the fact that among all the superior majors of the village guard organization, he is the only one who was oblivious of the existence of the memorandum dated 30/11/2018. But of course, he was aware only about the existence of the memorandum dated 14/9/2018. From his admissions that he was at least aware of the existence of the memorandum dated 30/11/2018, no inference other than that he had no option but to acknowledge his such awareness, purely to construct a foundation for filing the instant petition can be drawn. Incidentally also, from his statements, it can be inferred that till February 2022, he was unaware about the promotion of his immediate colleague Sri L. John Konyak, posted at the same station as he, who was promoted together with the deponent by the same notification dated 19/7/2021. Here also it is apparent that he had to construct a rough date of knowledge so as to.
Let us now see.
Yes.
Let us now see who is this L. John Konyak.
He was a superior major stationed together with the petitioner.
Let us see this 19/7/2021. Where is that?
Yes. It is the impugned.
Which page? Mr. Tompo?
I'll take a lordship to the relevant page. Page 33.
Page?
No.
85.
85.
85.
Yes, page 85.
Let us see. Let us see. Page 85.
85, yes. Notification.
L. John Konyak Subedar measure.
Yes.
So he was also.
Yes, and even E. Taiwan Konyak. In fact, they are from the same area.
From Mon.
Yes, from Mon. All of them were superior majors here at Mon.
Posted at different villages, interior part of the state.
L. John Konyak.
Yes.
And E. Taiwan Konyak.
Yes.
They were Subedar
Majors. Same rank as a.
Posted at Mon,
Yes.
same as the petitioner.
Yes. They are absolutely aware of what is going on, and their promotion, it cannot be hidden also, Your Lordship. The assistant commandant, they have been promoted.
So the respondent was promoted along with L. John Konyak.
Yes, the respondent is at serial number 3, Your Lordship. Serial number 3. This is the notification which the petitioner is challenging. He is claiming that he came into knowledge about this only in 2022. This was passed in July 2021. And in February 2022 only he came to know about this, even here in this case. He is constructing a very broad narrative in his petition. very vague and broad narrative, no specific details. And even after he came into knowledge about this in February 2022, he submitted his representation only in September.
L. John Konyak was posted along with the respondent only. Not
Yes, they are under the same station.
not with the not with the appellant.
No, appellant, they are together in the same place of
Appellant
posting,
also,
that is,
appellant
yes.
also.
Yes, appellant also.
But otherwise, L. John Konyak was is senior to the appellant and.
Yes, he was
respondent.
senior, but about promotions and about seniority lists, when all these officers know about these things,
All of them were in the same station.
all of them were in the same station.
E. Taiwan Konyak,
Yes,
Subedar Major, and L. John Konyak, Subedar Major.
yes,
They were posted at Mon along with the appellant.
appellant. And specifically, to my knowledge, L. John Konyak, that is why I have mentioned in this application, paragraph 8, they are there together. And very few posts, especially in the higher ranks, because under the village and village guards organization, from Subedar only regular employees.
Correct.
Very few of them. Subedar and then Subedar Major, then after that, assistant commander. So it's a very small knit community.
Below Subedar Major, these are all on contractual employee.
Yes, the others are just
Work charge or-
voluntary appointments. Yes.
And
voluntary,
thereafter, on
yes.
the basis of seniority or whatever.
Yes, yes, on the
They
basis of
are
seniority, they are
regularized.
yes.
They are regularized
Yes.
in the next higher post of
Subedar,
Major.
yes, Subedar. And from, it goes on upwards like that. So he's an officer of the police force. It's a police force, an officer. And claiming ignorance. That shows that he is incompetent to be an officer also, your lordship. Maybe we should go even to that extent. He ought to be vigilant. But after now, the right has accrued to me already. And even after I was promoted, more than 1 year after that, he has approached his honorable court. Praying for quashing and setting aside by promotion and also going all the way back to 2018 to rectify a senior release, which has already become final. And it will lead to grievous injury to the instant respondent.
Say, Mr. You have also not come with those citation, but I forgot that the year, but I still remember the name of I think it is Sada Shiva or something. Sada Shiva. Supreme Court has held that
Justice.
no, it's a party. Sada Shiva
Yes.
versus. There, the Supreme Court has clearly laid down that one should challenge the promotion or seniority not later than 6 months.
Your lordship.
That is very clearly laid down, Sadashiva's case.
Your lordship, I shall
forgot that citation.
Yes.
But that is very clear. That is also very clear, and this has been that has been referred to in many decisions. Sadashiva case. So, but it doesn't mean that when I am actually
Yes,
referring
yes.
to that, it doesn't mean that I am against you. Because
Yes.
actually your case has
If
to
that
be.
is the case,
No,
no case, Lordship.
As you have actually in the citation you have referred. It all depends on the facts and
Yes.
circumstances of each case.
Yes.
So we will
Yes.
examine whether you have been able to satisfactorily explain the delay in challenging the final seniority list. That is the most important thing here. Because It is on the basis of that final seniority list that the promotion has been given to the respondents.
Yes.
So the main crux of the issue here is whether you have challenged that final seniority list in time. And whether, of course, you were aware of the publication of that seniority list.
That is the only issue.
So I think we will have to also examine that.
Your
And
Lordship,
then,
it is, we have laid down laid out our
Yes.
case. Now it is for your lordships to.
we have a.
Yes.
taken down all
Just
your-
to verify one lordship, the
Yes.
query made by lordship. The appellant was aware about the first tentative seniority list. But how comes the second seniority list was not aware? That was the query made by lordship. The first seniority list was circulated, that is my case. But the subsequent immune seniority
First
list
seniority
was never
list-
published, and I made specific state it was kept undisclosed before in the commissioner office.
That is, I think that is the same case with the first provisional
Yes.
seniority list.
No, that was circulated. And it is not a case of
That
the-
is that is your submission.
Lordship.
That is your submission. But if we actually made a comparative reading of the first provisional seniority list and the final seniority list, we find everything more or less same. And whether it was circulated or not, I think that is your submission, which we will have to see.
Lordship.
Whether we will have to see.
Lordship.
Yes.
No.
No.
No, nothing.
Mr. Wati Jamia, learned counsel for the petitioner. Appellant, Mr. E. Tibapong, the learned government advocate for the state respondents, and Mr. Tongpok Pongoner, the learned counsel for the respondent number 5.
Seven.
Respondent
Your
number
Lordship,
7. Heard the parties at length, judgment and order reserved. Step lead, okay? Step lead. Citation, just let us first go to the file. After that, we will be asking all this one by one.
Print it and better print it.
Whether you can print
Print it and keep it alone.
Print it. Are you aware of what they have stated? The pages and all? Then in that case, print out, but please don't print out from Manu Patra. From here. Okay.